Welcome to Canadian Justice. I'm Christine Van Gyn, and today we're discussing the federal government's invocation and then retraction of the Emergencies Act in response to the 2022 trucker convoy in Ottawa. The Emergencies Act is a piece of extraordinary legislation available in very specific circumstances that gives the government special powers, like the power to create new criminal offenses and police powers, without recourse to Parliament, advance notice, or public debate. The charity that I work for, the Canadian Constitution Foundation, is taking the federal government to court over their decision to invoke this extraordinary legislation. We say its use was unjustified, illegal, and unconstitutional. But in order to answer the important legal questions about the government's use of the Emergencies Act, the court needs to have access to a full and complete record. But the government is refusing to disclose key documents that explain why they invoked the Emergencies Act. We're fighting this in court and seeking access to those documents. Here to explain the important development in the case are two lawyers representing the CCF, Sujit Choudhry and Janani Shanmuganathan. Thank you both so much for joining us today. Let's start from the beginning, Janani. On what basis is the CCF challenging the federal government's invocation of the Emergencies Act?
So what the CCF is doing is we are bringing a judicial review in federal court to say to the court that the federal government did not have the requisite reasonable grounds to invoke the Emergencies Act. The Emergencies Act is meant to be an extraordinary piece of legislation, and we say that the courts, the police, the federal government, they already had the existing powers that was necessary through the existing criminal laws.
So there's these documents that we're seeking that are supposed to explain what the federal government was thinking, on what basis they invoked it. Sujit, what can you tell us about those documents that the CCF is seeking access to?
So there's a few different kinds of documents. There are submissions that were made to the governor and council or cabinet. So those would be recommendations, a policy analysis. Then there's actually a draft of the order in council. We'd like to see, for example, if the order in council that was proposed is the same that was adopted. And then crucially, there are the minutes themselves of the cabinet meetings. And the minutes, not just of cabinet meetings, but also of something called the Incident Response Group, the IRG, which is a cabinet committee that was created by the Prime Minister in 2018 that met on almost a daily basis throughout the trucker convoy protests, and also during the state of emergency. And the reason we need those documents is to better understand why it is that the government felt it had a legal basis to invoke the act.
Go
ahead,
sorry,
please.
Sujit, I'm just wondering how they would help assess the legality of the federal government's use of the act. And kind of they've provided some public documents, but are those documents insufficient to explain it? Why do we need more information?
So the way this legal proceeding works is that the court has to decide whether the government had reasonable grounds to issue the public order emergency based on what's called the record. And right now, the public record is very thin. It basically consists of a single document filed in the House of Commons. And in relation to the legal justification for invoking the Emergencies Act, a single sentence in that document. And so it's far from adequate. And so we say that for the court to be able to do its job, it needs access to all of the materials that were before cabinet, not just the document filed in Parliament.
So they're refusing to disclose these documents. Janani, what is the basis on which they're refusing to provide these documents to the court?
So there is a provision in the Canada Evidence Act that allows the federal government to assert something called cabinet privilege. And so this covers discussions that took place during cabinet meetings, at cabinet, while they're making the decision. And it also covers the documents that were before cabinet when they were making this decision.
So obviously, cabinet confidence has been invoked in the past. We've got to go to commercial break now. In other cases, cabinet confidence has been invoked. I want to talk about some of those examples, some precedents, if this has ever been used before, and if there's a way around it. Because really, in order to challenge the government's invocation of this act, the government needs to present a case of why this was justified. And right now, there's not a whole lot of information. So we got to go to break. But when we come back, we will discuss all of that. Welcome back to Canadian Justice, where we're discussing the fight over the Emergencies Act and the government's claim of cabinet secrecy over documents that explain why they invoked this extraordinary law. Now, Sujit, the CCF is arguing that these documents should be disclosed. Is there a precedent for seeking access to cabinet secret documents?
Yeah. So to be precise, what we're asking for is the documents be disclosed to counsel only, and that the court hold a closed hearing in which counsel on both sides of the case can access the documents and refer to them, in order that the court can basically conduct a fully adversarial hearing, while nonetheless protecting the confidentiality of these materials. And there is a precedent for this. So about 20 years ago in British Columbia, there was litigation around the constitutionality of public sector wage restraint legislation. And the key decisions have been made by the provincial cabinet. And the lawyers for the unions proposed that counsel-only access be provided to the documents and they were able to persuade the judge that that was appropriate in the circumstances, because without those documents, the court couldn't properly adjudicate upon the constitutionality of the wage freeze. And so we're making a similar argument here. That the judge can't do their job unless they get the documents and that they're tested in an adversarial form. But we get that these materials are confidential, and so what we're saying the compromise is to have the documents disclosed just to the lawyers in the case, and for the court to conduct a closed hearing on these documents.
Yeah. So one of the questions that I receive a lot is, why can't they be disclosed to the public? I mean, we know cabinet secrecy is an important part of the Westminster system. So can you explain the idea of balancing here? What's the goal in having it on counsel-only basis? Why can't it just be the whole public?
Sure. So the reason for cabinet confidentiality is to preserve candor. And it's to enable ministers to have a frank discussion and to, quite frankly, disagree with each other about the appropriate course for public policy, and we want to preserve a space for that in our parliamentary system. It's important, and the courts have long recognized that type of privilege at common law, and so the general approach is that these documents are sealed for at least 20, if not 30 years. But what we're saying is that, sorry, go ahead, Christine. You want to ask a question?
No, keep going.
Yeah, and so what we're saying, though, is that principle has to be balanced against another one, which is to ensure that governments act according to the law. And the difficulty in this case is that if the government prevails in its attempt to keep all these materials secret, the court simply won't have the record before it that it needs to determine whether the government acted lawfully or not. And so this is an appropriate way to kind of, in a sense, satisfy both goals, that confidences can be kept, but at the same time, the court can get the materials and decide if the government has acted according to the Emergencies Act and the Constitution.
So it's important balancing in order for the court to do its job. So, Janani, without these documents, how could the court do this job? How could we ever assess whether extraordinary legislation like this was used properly?
And that's precisely why we're bringing this motion to get access to these documents, because our position is that how can the court do its job? How can we review the federal government's decision to invoke the Emergencies Act if we don't know what their justification was? And so that's precisely why we want to go to court and get access to this material.
Sujit, is there anything you want to add to that?
No, I mean, I think Janani has put her finger on it. And the other thing that we would say is this: as you know, the core of our substantive case is that the RCMP and the Ottawa Police had many tools available to them under the Federal Criminal Code and under provincial highway offences legislation to address any disruption caused by border blockades and by the protests in Ottawa. And what we'd like to know specifically is what those documents say about that issue, because we're very skeptical that those tools were not sufficient.
Well, as we know, the borders were cleared before the Emergencies Act was even invoked. So clearly, the existing police powers were sufficient to deal with what a lot of people, including us at the CCF, view is probably the most disruptive part of these protests, which was the border blockades that had significant impact on the economy and were cleared using regular police powers. We've got to go to commercial break, but we will be right back. Welcome back to Canadian Justice, where we're discussing the fight over the Emergencies Act and the government's claim of cabinet secrecy over documents that explain why they invoked the law. Now, Sujit, the government is claiming cabinet confidentiality over these documents that we think would provide some insight into their reasoning for invoking this law. How do Canada's laws on cabinet confidences compare to other Westminster systems? Are we more secretive? Are we less secretive?
So our laws are perhaps the most secretive in the world among Westminster democracies. So in the other Westminster democracies, and here I'm just referring to Australia, New Zealand, the United Kingdom, not the other parliamentary democracies, but those are the main ones. And also at the provincial level, and this is quite important, the cabinet privilege is a common law privilege, and the courts engage in a rough balancing test to determine whether cabinet privilege in a particular case should give way to other important interests. But at the federal level, Section 39 of the Canada Evidence Act vests in the clerk of the Privy Council, who's the head of the Federal Civil Service, the power to issue something called a certificate, and to declare that certain matters, certain cabinet materials should be confidential. And what the provision actually says is that certificate can't be questioned in the court of law, more or less. And so there's no other jurisdiction that has a law like that we're aware of.
So what you're saying is that the federal government has a law, a statute, that actually allows for even more secrecy over cabinet documents than they would have under common law.
That's true, and we're also saying that there's a reasonable apprehension of bias here, because what's at stake are the decisions of the very body that essentially has the power to declare these materials confidential.
Wow. So, I mean, it's certainly concerning from a transparency point of view. And when it comes to legislation that is so extraordinary, the Emergencies Act, that's supposed to be invoked for wars or terrorist attacks, for the government then to claim there's no ability to get any insight into why they invoked it, it's a huge transparency problem. Sorry, go ahead, Sujit.
Well, I was just going to say, I mean, I think it's important to put this in context, right? So if the government had provided a better set of materials to Parliament that provided a more comprehensive and transparent explanation of why it had concluded that the existing legal tools were ineffective in dealing with the blockades and the protests, then we might not be here. But that's not what they did. They
had that one sentence, right, in their document that was an unsigned, unsworn document tabled in Parliament.
And at the same time, right, they are invoking the fact that, or they assert that the discussions within cabinet were robust. And so we say they can't have it both ways, right? They can't both assert that discussions were robust, which is a tool designed to induce deference and trust on the part of Parliament and the public, but then on the other hand, refuse to let us examine the documents that would let us assess whether, in fact, those discussions were robust or not.
Very well put. Now, Janani, there is going to be an inquiry about the federal government's use of the Emergencies Act. It's an inquiry that the government's not doing out of the kindness of their heart as required by the legislation. But what can you tell me about it? How long might it take? What tools might it have?
So Justice Rouleau of the Ontario Court of Appeal has been appointed the commissioner of that inquiry. They're required to produce a report in February of 2023. So that's the timeline that they are working with. And just in terms of like a high level overview of what the purpose of the inquiry is, they're going to be looking at, why are we here? Like, why did the federal government invoke the Emergencies Act? What is the justification for invoking the Emergencies Act? Did they have the requisite reasonable grounds to invoke the Emergencies Act? And lessons learned. What can we take away from this going forward in terms of future emergencies and future opportunities to invoke the Act?
And who are the groups that are going to be participating in this inquiry? Is there an opportunity for public participation, including participation by the Canadian Constitution Foundation?
So the inquiry has invited people and organizations to submit an application for standing at the inquiry. The Canadian Constitution Foundation intends to apply for standing and participate in the inquiry. And it'll be up to the commissioner to decide who gets standing and who has the ability to participate in the inquiry.
Well, we'll obviously be watching very closely and hopefully be granted standing to participate. We're going to talk a little bit more about what that means when we come back. Welcome back to Canadian Justice, where we're discussing the fight over the Emergencies Act and the federal government's claim of cabinet secrecy over the documents that could explain why that law was invoked. Now, Sujit, there's going to be an inquiry into the invocation of the Emergencies Act. Will the commissioner of that inquiry have access to the documents, these cabinet documents, that the Canadian Constitution Foundation is seeking access?
It's a crucial issue. And so on June 1st, the commissioner released a document that was an update on his activities. And in that document, he said that he'd requested these materials for precisely the same reason that we've requested them, that he feels he can't discharge his mandate unless he understands the basis upon which the government reached the decision it did, and he needs those documents to assess that basis in the most comprehensive fashion. And what's not clear yet is whether the government will disclose those documents to him or not, and if they disclose them under what conditions. And if they don't, then it's entirely foreseeable that the commissioner might go to court, in which case his case, I suspect, would be heard alongside ours or in close proximity to ours. And certainly if our case goes up to the Supreme Court, which it very well could, his case would as well. If he does get access, then the terms upon which he gets access could be relevant in our case as well, because that might present a solution to the federal court for how to ensure that these materials remain confidential while at the same time allowing independent oversight of the executive's invocation of the Emergencies Act.
And that hearing that we're having is taking place on July 5th. So
correct.
So pretty soon. Now, Janani, the Deputy Minister for Public Safety said earlier, had a pretty shocking statement actually earlier this week. Originally, the minister himself had said that the Emergencies Act was invoked because the police asked for it to be invoked. But now the deputy minister has clarified that statement, saying that the police didn't directly ask for this specific law, but rather he says the minister means that the police wanted the kinds of powers contained in the act, which is a significant distinction. So what can you tell me about those statements and what that means?
So I think those kinds of statements and what's been revealed in the public record now just shows the importance of why we need access to the actual source documents. Like, we need to see what was before cabinet, what materials they considered, the kinds of discussions they had, the requests, and not just people telling us about things that happened, but not really knowing about what happened. We need to go right to the source to see, well, what was actually requested, what was considered, and why did they arrive at the decision that they did. It's not going to be often that we're going to have people, in the media say, well, you're right, I know that was a mistake, I've now corrected it. We can't trust it, right? We need to really see the source material.
So the hearing on these documents is taking place on July 5th. Sujit, is there any information about when the hearing on the merits, on the actual invocation of the Emergencies Act, what's the status of that?
Well, I think that's on hold for the time being. We thought that there'd be a hearing on the merits at the end of June or in mid-July. But I think that the hearing on evidence is basically taking place at that time. And the sense among the parties is that the losing party in the evidentiary motion will likely appeal. So it could be that the hearing on the merits will be a bit of a ways off. But on the other hand, I think everyone's motivated, and certainly we are, to try to seek that the appeals be heard on an emergency basis, so that the hearing on the merits can occur as soon as possible.
Exactly. You can't really put the cart before the horse, and we want to bring the absolute strongest case that we can. Sujit, Janani, thank you so much for all your work on this and for coming on today to talk about it. We've heard today about the Canadian Constitution Foundation's challenge to the federal government's invocation of the Emergencies Act and the fight to access secret documents as part of that legal challenge. This is a court battle that I'm obviously invested in as litigation director for the CCF. I believe that the Prime Minister's use of this extraordinary legislation was politically motivated and that we need to push back against the politicization and normalization of emergency powers. But what do you think? Was the use of this special law to give the government expansive powers to deal with a disruptive protest justified? You be the judge. Thanks for watching, and remember, a freer Canada starts with you.